Well, medical negligence is where you're bringing a civil claim against a hospital or a doctor, or a GP or a dentist, where you've undergone medical treatment for one reason or another, and then something has gone wrong with the treatment provided, which has then caused you an injury.
You're under no obligation to make a claim if you've suffered at the hands of a medical practitioner. Lots of people choose to do so, however, firstly because they want to make sure that similar mistakes don't happen to other people, and they think that by bringing a claim it can help to change the way that doctors and hospitals provide treatment. Other people bring a claim out of some sense of justice. They feel that it's the right thing to do. And other people bring a claim because, as a result of the medical negligence, they or a member of their family have been so badly injured or hurt that they need compensation to enable them to put their lives back together again and to manage with the consequences of the injuries that they've suffered.
Right, in order to bring a medical negligence claim, you can't just say, well, I'm not happy with the treatment I've been provided with and therefore I want to bring a claim. You have to prove that the standard of care provided to you fell below that of a reasonable body of responsible clinicians in that field. So the only way you can really bring a medical negligence claim is with supporting expert evidence. I mean, I can say to you, well, it doesn't sound like you've had very good treatment, but that doesn't mean it's been negligent treatment. In order to bring a claim, you would have to provide all your medical records along with your complaints correspondence or a statement saying actually what happened to you. And then we would instruct an expert in the same field to comment on the treatment that was provided. Most of our experts are medical legal experts. They're legally qualified as well, so that they know the test that we have to satisfy in order to bring a successful claim. So you need your medical evidence, your own witness evidence, any other supporting evidence, and you'll need an expert to say whether or not that treatment was negligent and whether it caused you an injury, and if so, the nature and extent of that injury.
The claim usually progresses by the patient or their family obtaining the evidence they need to support their case, obtaining the medical records and expert report. If that supports a claim, then you would write to the hospital or to the clinician or doctor involved, tell them that you're making a claim and set out the background and reasons for it. They would then have a period of time to respond. If they accept that the treatment they provided was negligent, then you would try and negotiate a settlement. Those cases don't usually go to court. If the doctor or the hospital doesn't accept that they've done anything wrong and they don't accept the treatment's been negligent, then if your experts continue to support the claim, then you would at that stage issue court proceedings, and then ultimately, if the claim doesn't settle within that process, there would have to be a trial at court. The majority of these cases either don't proceed beyond the letter of claim stage when you initially notify the doctor or the hospital of the claim because they have a robust defence, or if they don't, they tend to settle during the claims process. I would say that probably no more than 5% of cases that are started end up in trial.
Medical negligence claims apply to all medical treatment, so it could be anything from substandard surgery or delayed diagnosis and treatment, or failure to diagnose correctly a condition and perhaps give different treatment that made the condition worse. You can have mental health claims against a mental health trust for their failings to diagnose and treat or detain somebody for their own safety. Yes, so dental claims we have where dental treatment has gone wrong or has not been sufficient, and people have suffered or lost teeth for that reason. Is any type of medical treatment really.
A patient or their family has 3 years to bring a medical negligence claim, either from the date of the treatment which they are alleging was negligent, or, more usually in medical negligence cases, 3 years from the date when they first became aware that the treatment that they'd suffered had been negligent and that they'd suffered an injury as a consequence.